Hey everybody, I'm going to try to do this as fast as I can, hopefully one take. We lost power all night long, just got it back. It's like 60 degrees in the house. I'm going to down this hot coffee, thank the Lord for these woobies. Try start trading. And I want to tell you all about South Carolina. I got a bunch of emails once I could finally get service. I know South Carolina's Senate passed the bill on the third reading yesterday, and it's back to the House because they put some amendments in. And we're going to talk about those amendments, guys, because they've gutted constitutional carry. And I know everybody in South Carolina right now is excited, but you need to be aware of this. So for those who aren't aware, constitutional carry right now, it's a race between South Carolina and Louisiana to see who's the next state that's going to join the roster. And this bill, it's come on, Jared, House Bill 3594. And this has been it's been in the process since December 15th of 2022, this bill. And it passed the House. I got this up. This is the actual website for their legislature, so I can get the roll calls. It passed the House roll call vote on February 22nd of 23. Remember, I covered that by a vote of 90 yeas to 30 nays. And then it was read again. It was 87-26, and then it was sent to the Senate. The Senate, their first time they voted on it was 24-18. There was an error corrected. Then they voted on it again. It was 27-18, and then there was a bunch of debate and some amendments. And the amendments are the problem. Now, it did pass 28-15 yesterday, and it was referred back to the House with these amendments. And I started to dig into these amendments. I actually got a text from Dudley Brown from National Association for Gun Rights, and they sent a letter to the legislature in South Carolina detailing the problem, and it's a pretty good letter. I want to show it to you. They sent it to the Speaker of the House, G. Murrell Smith, Speaker pro tempore Thomas Pope, Majority Leader David Hoyt, and Minority Leader J. Todd Rutherford. And you know I love holding politicians accountable. And they said, "Dear blah, 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 and members of the South Carolina House of Representatives, next week your chamber will take up the Senate's amendments to H. 3594, the South Carolina Constitutional Carry / Second Amendment Preservation Act of 2023. This bill was rightly referred to as constitutional carry when it left your chamber, but it cannot rightly be so called now due to the passage of the Senate Amendment number 36, which creates a new criminal penalty of exercising the constitutional right to carry a weapon publicly without a permit. This alone irreparably compromises a bill which was originally designed to honor the inalienable right to self-defense as enshrined in the Second Amendment. The Supreme Court emphasized this right in New York State Rifle and Pistol Association versus Bruin, which states that the constitutional right to bear arms in public for self-defense is not a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. Not content with violating one provision of the Constitution, the Senate language goes on to trample the Equal Protection Clause of the 14th Amendment to the Constitution by applying this new criminal penalty only to a disfavored portion of the South Carolina citizenry. Under this language, individuals who exercise their constitutional right to carry a weapon without a government permission slip are penalized criminally for doing so if convicted of certain other additional crimes. However, individuals who commit those crimes do not get the penalty if they carry a valid concealed weapons permit at the time. This is a direct violation of the Second Amendment right to carry in public without the permission of the government to do so. No sane lawmaker would ever propose creating a journalism permit and creating a new criminal penalty of speech without a permit to accompany other criminal convictions. Yet, the South Carolina Senate agrees that the Second Amendment should be treated as a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. Moreover, this language raises serious due process concerns. Individuals who commit crimes should be held accountable under the law only for those crimes, and every single South Carolina citizen stands equal under the law. The Senate's version tramples that due process principle by creating two classes of citizens and two classes of public carry, one with government permission and one without. This approach is both constitutionally suspect and ripe for challenge, and while court remedies are pending, puts some of our most vulnerable citizens at risk of disproportionate treatment under this inherently unjust law. The Senate's language violates the Second Amendment of the United States Constitution as well as the Equal Protection Clause for the 14th Amendment. You are advised to reverse course and remove this language forthwith, and to refrain from passing into law any legislation carrying this provision. Should this language be passed into law, the National Association for Gun Rights will have no choice but to refer this matter to our Foundation for Legal Action and Remedies to protect the Second and 14th Amendment rights of South Carolina citizens. Sincerely, Dudley Brown, President of NAGR. So I wanted to bring this to you. I've been trying to record this for a while, but again, no power, no internet, no lights. It's been a difficult day, but blackout coffee and TriStar Trading are saving it right now. I wanted to bring this to you because I got a bunch of people in South Carolina that watch my stuff, and I think constitutional carry should be the law of the land. In fact, it is the law of the land. It was written into the Constitution. But your version right now, South Carolina, has been gutted by this amendment in the Senate. Hopefully now that it's gone back to the House for consideration, hopefully the House removes this amendment and we don't have a shell of constitutional carry like Tennessee has. Tennessee's constitutional carry is not true constitutional carry. I discussed a bill yesterday morning that's looking to rectify that as well. Be a thorn in their side, South Carolina. I'll put a link down below to figure out who your representatives in your legislature are so that you can ring them, call them, email them, hit them on their Twitter, hit them on their Facebook, jam them up on their Instagram, hold them accountable. You're their boss. They only do what you allow them to do. So with that, I hope you have a fantastic day. Stay warm, America. Be safe, y'all. Carry a gun. It's our right. We're our own first responder. The government can never save you. They haven't saved anybody. Have a great day. Take care.